One of the foundations of intellectual property is you can't protect abstract ideas.
Jeff Holman, founder of Intellectual Strategies, is transforming how startups and scaling businesses access legal support.
Having the ability to bring in somebody who's been in that managerial role brings a level of competence that you can't get in a lot of other situations.
By creating the first fractional legal team, it allows companies to get expert legal advice as needed without the cost of a full-time in-house team.
There's just some robustness to this model that even COVID didn't really disrupt it that much.
This flexible model helps businesses navigate growth and challenges efficiently. With degrees in electrical engineering, law, and an MBA, Jeff is a versatile entrepreneur and attorney with over 20 years of experience. His expertise spans intellectual property, business strategy, and technology law, making Intellectual Strategies a key partner for ambitious companies seeking smart, scalable legal solutions.
In the patent world, you don't want to disclose what you're doing. You don't want to tell people about it until you have some protection on it.
Hey Jeff, welcome to the Nomad Solopreneur Show.
Gabe, hey, thanks for having me. It's great to be here.
You have such a diverse background. You have a degree in electrical engineering, you have a degree in law, and an MBA. How come?
I think it's the same reason that I work with startups and scaling companies. I kind of like chaos. So I see things and I'm like, oh, that looks cool. Let's see what happens. Let's try this, see how that goes. So I just have always had an interest in learning, and that's led me to getting different degrees, which, also kind of ties into when you're doing a startup or you're working with startups, you just run into all sorts of different issues. And so it's a matter of really seeing a lot of things so you can then speak about a lot of things from both knowledge and experience.
Yeah, that's the thing, right? When you start learning something and you realize that, this might be helpful as well, might help in other parts of my business and so on. And when it comes to the law part, because you have a very different approach to most traditional law firms, you have a fractional approach to it. And in a world that it's slowly going to a remote first, I think that's a very interesting approach. And in my opinion, is the future. How do you come up with the idea?
Well, I'd like to say that I designed it, but I kind of fell into it and then I designed it. So I was working in my own law firm for a while, helping clients mostly with patent issues, working with a lot of inventors from big companies, small companies, and decided that I wanted to be broader than I wanted to help with all the other, like I said, the chaotic issues that the startups came up with. And so that's when I went and got my MBA. And I had this 5-year plan to go into a general practice firm, eventually become general counsel with a technology company. And that 5-year plan became a 5-month plan because somebody came and said, hey, come be our in-house attorney, meaning I was no longer practicing in my own business. I went and I was practicing as the only attorney in that technology company. When I transitioned out of that, this is where I just kind of fell into what people would now call outside general counsel or a fractional general counsel role. So it just kind of happened. It was supposed to last a couple months, but it ended up lasting about 1.5 years. And during that whole time that I was in-house, and then the time that I was outside general counsel afterwards, I recognized that I had been practicing law in a way that I would call the wrong way. I was doing it like all of the attorneys taught me to do it, instead of how the businesses really needed me to do it. And that just kind of evolved into what it is today, which is not just a single attorney practicing as outside general counsel or fractional counsel. We actually approach this as a team. I have 5 attorneys with different expertise, and our 5 attorneys as a team comes in and is a fractional legal team for startups and scaling companies. So it is really unique. I've talked to a lot of people about it. I think people should be practicing this way, but attorneys are really hard to adopt new models, and so they kind of just stick with what they know. Whereas I'm out there, I'm out there trying new things, experimenting, and we're having a lot of success with this approach.
Experimentation, it's always the path to growth, right? And not just on a personal level, but on a business level as well. And for those that are not familiar with the fractional model, can you dissect it for a bit and explain it how that works?
Yeah, certainly. So a fractional model really is the opportunity for a business, in this case, to hire somebody who's highly experienced for for kind of slices of time, right? A lot of times somebody will say, I need really skilled marketing experience, maybe even executive level marketing experience. So they go and hire a fractional CMO, and that fractional CMO is available to the company 5 hours a week or 10 hours a month or whatever scale that company needs. So you have fractional CFOs, fractional CMOs, fractional CEOs even who will come in and be the CEO of your company. We happen to be fractional legal. So we come in and we take care of the legal things. Most of our engagements are for a set amount of time every month, not necessarily a set person or set hours, but a set amount of work that we do. And so sometimes in our team approach, sometimes people will need, they'll need patent help, or they'll need trademark help, or they'll need corporate help, or business entity, or fundraising, or disputes, whatever it might be. And across the attorneys in our team, we actually bring the right attorney with the right expertise at the right time to the client. And all of that happens not on a full-time basis and not on a more distant hourly basis that you get from a traditional law firm, but on what we would call a retainer fractional basis throughout the month.
I love that explanation. And maybe for some people will be like, okay, so why should I bring someone on a basically part-time basis in my business? What are the benefits of that? Apart from having access to that executive level type of support, can you expand on the benefits of this model?
Yeah, one of the big benefits, and the reason a lot of people will do this with, especially with a general counsel role, is that as a small company, you end up interfacing with a bunch of attorneys anyways. You have an attorney you hire to help with fundraising. You have an attorney for your patents, and you end up hiring 6 or 7 different attorneys depending on what you're dealing with that month or that week. And so, an outside general counsel in this case would come in and they'll actually help manage those outside relationships. So it often means you can save money with somebody in-house experienced who knows how to work with those types of outside attorneys. You can save money on the engagements. You can get better results. You can monitor quality. And so you really have somebody with experience, with in-house experience, helping get all of the other services you need. Of course, in our case, we happen to have a lot of that in-house experience on our own team as opposed to having to go out and hire additional attorneys outside. But that's the biggest benefit of having the strategic level experience in-house, is really managing costs, managing work quality from all the people that you're hiring anyways. And instead of having, the alternative really is to hire one attorney when you're new, hire one attorney, bring them in-house, and then expect them to do all the work. Well, like a lot of professions, that's not how attorneys work. Attorneys have their own expertise, and they might be really good at drafting vendor agreements, but they might not know anything about employment law, for example. So having the ability to bring in somebody who's been in that managerial role, if you will, really brings a level of competence that you can't get in a lot of other situations.
Yes, indeed. And that's the power of it, right? That flexibility to have that expert alongside you when you need it, but not in a full-time role that in general is quite expensive to hire someone full-time for every specific role in your company. And the great examples that you mentioned, like either with a CM or a CTO or even a CEO, like having those people full-time in-house can pile up. And that's not the way to go, especially today. And especially if you're a startup that is just getting traction and searching for funding and so on. And I think it's still an underrated approach. And both from the perspective of businesses, but as well from those that want to go on this path of being a fractional expert in different fields. And while diving a bit deeper into this topic and seeing this trend going, especially at a global scale, how do you see this trend moving forward? Since after the pandemic, a lot of big companies are trying to bring people back in the offices. Other more agile and remote first companies are promoting more and more the remote work. Do you see a future for the traditional way of doing things, especially that you are involved in helping so many businesses, or do you see a future for the fractional mode?
That's a great question. I think we're going to see both for a long time. Fractional is certainly a growing model, and I think it will continue to grow. I think it will gain a lot more traction than it has, especially in the legal industry, where it's pretty new and attorneys aren't used to providing services that way. Whereas in finance, you see agencies essentially popping up with 100 CFO type people who will come in and they'll offer fractional CFOs, services. So in the legal field, it's a lot more new, but I think it's going to just continue to grow. It really is an impressive way for businesses to get all the services that it needs on a really economical model. So it's got to grow. Now, the idea of bringing people back in house, nothing wrong with that. I think we're seeing a lot of companies, especially right now, that are trending back that direction. It will be interesting to see if it works because so many people have gotten used to this distributed model. In fact, when COVID hit, I almost felt a little bit, I don't know, a little bit self-conscious. We had designed prior to COVID, we had designed our practice with our attorneys to actually be a remote first environment. We had an office, we went into the office, but everything was built to allow it to be remote first just because we wanted that capacity to expand and bring in talent from wherever we could find the right talent. We didn't want to be restricted to, who could show up to the office. So when COVID hit, a month in, people were like, some people were devastated and they'd be like, how's your business doing? And I'd say, we're kind of operating the same as we did before because we were already built, to be remote first. And our team is doing well. And the clients that are doing well, we're able to service them about the same as we've been doing the whole time. So there's just some robustness to this model that even COVID didn't really disrupt it that much. And the value that clients get out of it, I might be saying this too much, but I just don't know how you can beat the value of a fractional service with full-time employees unless you just happen to be right at the right time in your business with the right funding and the right mix of legal needs that it makes sense to hire somebody, then sure, go ahead and do that. But there is a very long runway between the time somebody has an idea and the time that they really should consider putting their financial resources towards hiring a full-time attorney or a full-time CFO or things like that.
Yeah, true. Especially because that's the reality. Like, you don't have the amount of work needed for someone to stay full time in house and so on. And on that note, how do you figure out how much time, or for as a fractional, you come on different pricing tiers, or how do you realize how much time is needed from your end or the client side, how much time they will need you to come in and do the work, how that works out?
So that works like a lot of we can just say it's like a lot of consulting engagements. Although I hesitate to say consulting because when I've had clients use consultants in the past, a lot of times it's a lot of work and a lot of money and some ambiguous results. But for a fractional type of executive, I mean, the company knows when it needs some strategic level decision making power, right? And so you're like, I really wish I had somebody here who could help manage my marketing at a strategic level or manage my legal at a strategic level, whatever it might be. So we go in at that point and we say, how do we help you roadmap the next 12 to 18 months? We want to look from a legal perspective in our case. Where are you headed? What big decisions are you making? What types of obstacles are you running into? If you're going to be hiring, if you're going to be raising money, if you're going to be launching a new product, if you're going to be rebranding, if you're going to be doing one of these big events in your business, and it's never perfect, right? You're going to rebrand sometime in 8 to 12 months, perhaps. Okay, that's good enough. If you're going to be doing these big milestone events, then we'll help put together a roadmap for that, and we'll say, well, typically you're going to need to do, these types of things in your business, and you're going to need to put these types of documents together for these events. And so we really roadmap it out, and then we try to look at that full timeline and say, how do we flatten out the fees so that you don't have a lot of ups and downs in, big legal costs one month and nothing the next month? How do we flatten it out so it's predictable yet sufficient to cover the milestones that are on your roadmap as a business? So that's how we do it, and I think that's to one degree or another how a lot of fractional executives would look at this in some scoping call. The one difference we have is we look at it and, because we're a team, because we have a breadth of experts on our team, and we have the ability to scale up or down with our clients as they're going through their growth stages, we look at it as an indefinite type of relationship. We want to be with somebody, aligned with them for a long time until they kick us out or something, right? We want to work with them through all those growth stages. Some fractionals, especially where you have an individual type of person come in, they won't necessarily have that same indefinite time frame. They might work in chunks of time, a 3-month project or a 6-month project, because they know that once the growth of the company exceeds their capacity as an individual, or the amount of capacity they want to allocate to one individual client, they'll have to find that client would have to move on to the next stage. So that's maybe another difference with the way that we do it as a team.
Yeah, indeed, because that's the power of having a team around it. Even that I'm personally big on being a solopreneur and one-man show, of course, with contractors and so on, but having that luxury of team expertise and being able to go to different growth phases, that's powerful. And speaking of growth phases and the usual challenges businesses face, especially around intellectual property, I'd love to dive a bit into the topic since a lot of people, or especially those that I work with, like coaches, consultants, and they have a specific methodology through which they help their clients. And some of them have this fear that what if I share this and a competitor's comes in and basically bought my services or buy my program, and they just copy it? How we can get protected on that?
That's a great question, and there's not one right answer, but I do think that strategy and intellectual property are part of the right answer in every case. And so let's dissect that a little bit, right? And I'm coming at this with my background. I was a patent attorney I'm still a patent attorney, although I don't do that day to day, but I did patents for a long time, trademarks for a long time. And our clients often have very IP centric needs, just given the background that I have. So this is right in my wheelhouse. So when you have coaches or somebody who's developing a business around their intellect, around their ideas, uh, intellectual property is kind of a natural way to proceed. So for that type of intellectual property, you're probably dealing mostly with trademarks because you're dealing with the brand, the value that they are developing through their branding. In some cases, you might have patents, but it's a lot more rare in the coaching type of and consulting type of settings. And so you're probably dealing with primarily trademarks. You're also going to have copyrights. Now, I don't want to leave those aside because copyrights are important, but in the United States, copyrights don't necessarily come into play as often just because the value of the company, when a coach looks at building that company and what they're going to do with that long term and why people come and buy from them and why somebody someday might invest in them or they might sell their company someday, the value that's contributing to that enterprise is coming mostly from the branding, more so than from the copyrighted materials. That being said, they're layers, right? You have IP is often layers. You have copyright layers and trademark layers, maybe patent layers, maybe trade secrets, and then you have all the contractual rights that you build up around those layers. Those are what I would call the 5 aspects of IP. And so in this case, we'll probably focus on trademarks. How does that sound so far?
Sounds far, and it sounds good, and I want to get a bit more easy to understand for everyone. Like, for example, for myself as well, so I'm not really familiar with all the terms. So let's try to make it around a specific example. I have a specific methodology that I use with my clients. Like, it's a step-by-step process, but it's nothing groundbreaking because I'm in marketing, so you cannot really reinvent the wheels. Of course, I can come up with fancy names for the steps. I can come up with a fancy name for the frameworks and so on, which I probably can trademark. But how that actually works in a way that, let's say, an idea that I share was previously shared in different forms. I can still trademark the entire framework, or how can I do it in a way that...
Yeah, no, that's a great question. Before I answer it, would it be helpful to just describe what those types of intellectual property are? Would that be helpful here?
Yeah, of course. Yes, please.
Let me do that. So just because I think some people, I get so caught up in what I have been dealing with for 20 years that I forget to sometimes explain it in a little bit more understandable level. So patents deal with inventions, right? And most of the time it's a new thing that you've created, not like a framework thing, but like a device, a tangible invention of some sort. There's also some design aspects to patents that you can protect, but that's like, what does the new thing look like? So what does it do? What does it look like? That's the patent world. The trademark world is all about brand. So anything that you're using, a name, a logo, a slogan, even a color or sound perhaps, you can get trademark protection on, because you're using that thing, that mark we call it, as part of your brand identifier, right? It indicates to somebody where the source of the goods or services, the source of the products or services are coming from. So the name of a company or the name of a product or the name of a framework, as you mentioned, that's all branding, right? Tell somebody, oh, that's coming from this source, from this podcast, from this consultant, from this law firm, or whoever it might be. Copyrights are all about works of authorship. And authorship doesn't necessarily is not limited to words, right? It's any type of work of art. So you create a painting, you create a sculpture, you create musical lyrics, you create a play, you create anything that's a creative work of art, you can then copyright and protect that. And you're probably aware that there's sometimes overlap between the copyright world and the trademark world. Copyrights, you create a new graphic, and that new graphic is cool and nobody's ever created it before, so you want to own the copyright on it. Well, then you use that graphic as part of your brand. It's your logo. And now you trademark it as a logo because you're using that graphic for branding. So you can get both copyright protection and trademark protection on the same thing, but they're different types of protection. Trade secrets, we're not going to go into right now necessarily, and contracts are just the different agreements you enter into with different people around the other types of IP you have. So I hope that's helpful to maybe set the stage going.
Yeah, very easy to understand right now. And especially, I would like to dissect a bit the trademark part of things, since now everyone is building their personal brand. Everyone is putting themselves out there, and apart from just their name, they might building, as you mentioned, some products or some things that they want to trademark or they want to make theirs. And especially when it comes to protection, since from my little understanding on trademarks, you have to register them and you have to protect them in different jurisdictions. How expensive is to protect, let's say, a brand name all over the world, or just you should focus on certain parts of where you practice your service? Or
Yeah, that's a great question. And there's a balance, right? Because intellectual property, including trademarks and all of this, they're all subject to individual countries or jurisdictions. So if you want protection, you have to protect it in one country, or perhaps in one union, one group of states or countries. And so it could be horrendously expensive to protect a patent or a trademark in every country in the world. In fact, when I used to do patent work for IBM, for example, they never came and said, "Hey, we want to patent this everywhere." they would say, we want to this is really high priority. We want to patent it here in the United States, and we want to patent it in these 2 or 3 other countries. Not 10, not 25. I did have a client one time who said, I want to protect this in 25 different countries. And I was like, no, you don't. That is so expensive. Not even the big companies do that. Trademarks, on the other hand, you might go into more countries than with patents because your brand has a broader reach than maybe the invention would have as far as where it's manufactured and where it's sold. But your brand might be, you might operate and sell services, for example, in 15 different countries. If you're large enough and your revenues justify it, you might want to protect your brand across those 15 different countries. So it still can be expensive, but it's not nearly as expensive as the patent world, just as a point of reference. So let's say in the US, it's going to take, a few $1,000s probably to get a trademark on a federal registration on your brand. And let's step back 1 second because there like everything, there's always layers, right? In the US and other countries, you usually have to specify the mark that you want to protect. And if you have a logo, that's a mark. If you have a name, that's a mark. If you have a slogan, that's a mark. You might have different marks. For each mark, you then have to say, I want to protect that mark with this type of services or this type of goods. And you have to select different classes. Business consulting is one class. Law firms are a different class. Various types of products are different classes in the US and, well, internationally, because they use an international classification system. If it's made of leather, it's in a class. If it's made of metal, it's in a class. If it's made of other, so you have to pick the marks and you have to pick the classes, and then you have to register each mark in each class that you want. So you could see that even in one country, you might have 3 marks in 4 different classes, which multiply those together, and now you have 12, essentially 12 filing fees that you have to pay and 12 examinations that you have to do for that one business. So if that's the case, then you take that and you go into other countries, and other countries don't necessarily do it the exact same way, but there's, again, a multiplying effect. So it does multiply as you try to protect more things for more types of goods and services in more countries. So if you were just budgeting, you might say, it's going to cost me a couple $1,000s per country, per mark, per class to get this protected. So if I want to protect a name and a logo in the United States for 2 different classes, I'm probably $5,000 or $6,000 into this to get protection. And then depending on who you hire, you might be a little less than that, or you might be a lot more than that, depending on what they charge. But then if you go into other countries, and for trademarks, you're going to want to protect where you operate, right? If you have sales in the United States and Australia and Japan and, parts of Europe, you might want to file in the European Union, in Japan, Australia, and the United States, if you've got operations, right? If you don't have operations in parts of Africa, you don't want to file there. It won't do any good. The market might not be worth protecting for the types of services you do anyways. So you would pick the areas where you operate, pick the marks that you want to protect for the types of services and products that you're selling, and start that process. Of course, if you're a startup, that sounds overwhelming and extremely expensive, and it probably is more expensive than most startups should dive into initially. So we'll often talk with startups and say, what's the best way to protect your brand with the least amount of marks, with the classes that you're actually selling in right now, not the ones that, because every founder says, well, I'm doing this, but eventually I'm going to do this and this and this and this. We say, okay, let's protect the thing you're doing with the brand that you're using in the place you're at right now and get started. And then we can often file in other countries later on, or maybe even tie those together through some of the international treaties and agreements that countries have for trademark protection. Anyway, believe it or not, that's probably the short answer to the question.
Thanks so much for sharing. And I want to ask about the right time, because you very well mentioned that you don't have to do it to do everything from the beginning and so on. And I have a particular example. I work with quite a big startup that eventually raised funding from Horowitz and so on. So remember, they didn't even have a logo until after like 6 or 7 years in business. And that's just an example. So when is the right time for a startup to actually start protecting their brand or their trade secrets?
I like that question because it helps me illustrate that some of the differences between some of the different types of IP and the different layers. I guess that's the theme today is layers of intellectual property. So in trademarks, there are a couple different types of protection you can get. You can start using your branding elements anytime, your name and your logo. And this is in the US. Other countries, again, have some similarities and some have differences. But in general, you can start using your branding elements and you could put a little TM next to those. That's just an indicator that, me as a law firm putting a TM next to it means that I'm intending for that to be a part of my brand. And that TM just says, I think I've got some common law rights in this mark. Common law rights are what you have by using it without having a registration on it. Okay. That's some level of protection. Not the best, but it's something. You can also register it at the other end of the spectrum. You can register it with the federal government here. And most countries will have that. You can register with the government in that country and you can get really strong protection, right? And so some countries will have kind of that court recognized protection of common law, and then they'll have that federal registration level. To get started using your branding and protecting your branding in the United States because of that common law layer, I tell a lot of clients, listen, just if you don't have budget for it, the sooner you start using your branding, the sooner that common law right attaches to your branding. So it's advantageous to get your branding out there sooner, using it with your products and services. That's the opposite of what we tell people if they're dealing with inventions and patents. In the patent world, you don't want to disclose what you're doing. You don't want to tell people about it until you have some protection on it, because that disclosure will actually trigger certain limitations on your ability to get patent protection later. So it's kind of a two sides of that coin. Start using it soon with trademarks. Get it out there with patents. Don't use it until you get some protection. So
To make sure I understood, especially the trademark part, so you still have to register. You don't just simply put a TM next to your logo and it's protected, right? So you still have to register it, the trademark.
you
You don't have.
you don't have to. So you can actually, yeah, you can use your trademark, you can use your brand as much as you want, and you have some level of protection doing that, but not the best protection. I I think it might be helpful to stop and explain one more thing, because this is why people hire us, is because there's a lot more to it than you would think there should be, but it's just the way that it is. So people come to me and they'll say, "Hey, I want to get a trademark on my brand. I'm launching this new thing and I want to put it on there. I love the logo that I created. I'm going to use it for everything." I say, "That's awesome. What is it you want?" Because I want to make sure that I've got the right objective. Do you want to make sure that you can protect this so that other people can't use it without your permission? Or do you want to see if by launching this brand, somebody else will think that you're infringing on their brand, right? Are you protecting this to stop other people? Or do you want to make sure you're not doing something somebody else is going to be mad about? Those are two separate questions. They're similar, but they're very different from a legal perspective. And so I think your question kind of gets to that. Do you have to register it to use it? No, you don't have to. If you don't register it, you don't necessarily have the strongest rights to stop other people from using it, though. And even if you register it, that's not a clear indication of whether or not somebody else will think that your use of your mark, your brand, your logo is too close to their own brand. So there are a couple questions that we try to work through with our clients. The short answer is you don't have to register it.
Uh,
If you do register it, you get protection that you can enforce, and you get some kind of pseudo assurances that you're not infringing somebody else. Not for sure, but it kind of, people use it that way. They say, well, if I got my mark, then I probably am not infringing somebody. And so they'll think of it that way.
Yeah, that's interesting perspective, and especially because I'm thinking like I have my business for a couple of years, and I never thought about registering. And of course, I at some point I was searching for the same name and see if others are using it in different ways, and luckily they don't. But for example, when it comes to going back a bit to the initial question around the framework or the, let's say, unique methodology that you're using, I think
Mm-hmm.
that's much more important to protect rather than the logo. What do you think? Like, it's, since if someone comes in and just they see your methodology, they like it, and they start doing it themselves, and they're like, I invented this, I protect this, now it's mine. How you actually get protected there? And not sure if I asked the right question around it, and if it's actually, you're actually able to protect that in some way.
Yeah, you asked the right question, and you kind of answered it. It is hard to protect that in an absolute way because one of the foundations of intellectual property is you can't protect abstract ideas. And a framework, a business framework or methodology or an algorithm or other abstract, like, the idea. I have people do this. In fact, my wife does this. Hey, I've got this awesome idea for an invention. I'm like, what is it? And she says, you know how when this happens and it's a problem? I'm like, yeah. Well, what are we going to do to solve it? She says, well, I don't know what we're going to do to solve it, but if somebody solves it, that'd be an awesome invention. And I'm like, okay, we have a disconnect here. The idea of solving the problem isn't really protectable. If you come up with the solution, you can protect it, right? A framework, like a coaching framework or consulting framework, is kind of the same way. It's more like a math equation, and you can't. And a math equation is just a way to think about ideas and solve ideas, right? If you apply that math equation to practical situations and you create something new, then you could protect it, like with patents or whatever. But if you just have this idea that E equals MC squared, that's considered an abstract idea. And so with a framework, it's really an idea. It's still in the idea stage. And protecting it is going to come down to some combination of layers of IP, maybe a copyright on the white papers that you use to describe the framework. As you mentioned before, a branded name that you give to the framework or something like that. Maybe trade secrets. You have information about how you teach this secret. And when you teach it, if you have clients who are willing to sign non-disclosure agreements or confidentiality agreements or something like that, you teach it to people in a confidential setting and you ask them not to share that. And that way it remains a secret. So you have to kind of use these layers. And again, of all those layers, I think the branding is the best one. But for what you're asking, I can guess that you're thinking, well, that's not as good as I wanted. I wanted a better way to protect it. And in this case, I'm the bearer of bad news to say there's probably not a better way to protect it than putting those layers that we talked about in place.
That's painting a great picture because now I have more clarity. I understand better the layers and how to protect. And at the end of the day, what I always say that is I got this question a lot from my clients, and they were like, the thing is that you can share all your knowledge for free, but people pay for implementation. And that's most of the thing that people miss. Like, you want to put a lot of effort into protecting your work because maybe it's your life work there. Like, gather all the knowledge that you have and you want to share with the world and help others solve a problem. But at the end of the day, the clients that will pay the most are those that pay for implementation, not those that you, I don't know, the do it yourself type of approach in which you just gather the information and try to figure out yourself. And adding these layers that you mentioned to protect the brand, to protect, make sure that no one else use it for different purposes, because some people will just try to play you down and use your brand in the wrong way, let's say. And on that note, for example, especially when it comes to being online, now it's quite easy to, let's say, if someone talk badly about your brand, and if it's not true, you can just submit a request to Google to remove that link. And having trademark protection helps with that, or is not
In
really?
some settings, yeah. Yeah, well, in some settings, trademark protection is actually really helpful. In a situation with disparagement or negative comments like you're describing, that might come into play. Let me tell you where we see this happen. And that, well, a couple things. One, when you've built your brand, whether it's trademark protected or not, when you've built your brand strong enough, it kind of helps to absorb or deflect some of that negativity that might come in, right? And and since you're building your brand so that people can, when they come and they say, well, I want to do this thing with my business, you want them to know to look for the thing that you've branded anyways, right? So your brand helps them find you, and it helps also deflect or maybe absorb, if we want to call it that, some of the negativity that might come in, right? And if your brand is strong enough, that negativity is not going to really damage your brand. Uh, when you get onto platforms on the internet like Facebook and Instagram and other platforms like our e-commerce sellers on Amazon, and all these platforms or marketplaces really try to have a kind of an administrative layer that's super easy to manage. They won't get in and resolve disputes in a legal way, but they will say, hey, if somebody comes along and let's say they register a Facebook page that uses your brand and they want to use that to then speak poorly of your brand, you could go into Facebook and say, well, this is my brand and I'd like you to take that other one down because it's a fake. Facebook is the test that they like to use that makes it really easy for them is they say, okay, send us your trademark. Send us your trademark registration. And if you have a registration, they're probably just going to take it down. No questions asked. If you don't have a trademark registration, you can't send it to them. And then they're not going to they're not going to be able to check the box on their side and say, well, they have a registration, we can take it down. It's kind of the threshold question, the yes or no question that a lot of platforms use. Do you have a trademark? Okay, we believe you. Do you not have a trademark? Well, we can't really do anything about it. So it comes into play in that sense a fair amount when you're on platforms like that.
And on that note, since I see a lot of impersonators, especially on this type of platforms, can you protect your actual legal name with a trademark?
Yeah, well, are you saying when you say legal name, do you mean your personal name?
Yes, exactly. Yeah.
Or do you mean
No, your personal name.
oftentimes you can't protect your personal name, right? There are different restrictions about what you can and can't protect. Each country is going to be a little different. In some jurisdictions, you're not able to protect a personal name unless it becomes so famous that it becomes a brand in and of itself, right? So there's ways to protect things that become famous in a brand setting that you couldn't protect by it, without that fame. So
What famous
that's maybe a little bit.
in that sense, like how big a brand? If you can give him an example, I don't know, Tim Robbins, for example, or
Yeah, Tim Robbins. I haven't looked at his portfolio, but he probably has trademarks on his that incorporate his name in a lot of places. Whereas if I go to the trademark office, the U.S. Patent and Trademark Office, and I say I want to trademark Jeff Holman for legal services, they're going to be like, well, that's not allowed unless you can show us that people, that your market already has an association between the name Jeff Holman and legal service. And it's got to be so great a connection that when they think of Jeff Holman, they don't even think of you. They think of legal services, right? And so it's got to, like, when you think of Tim Robbins, you might think of Tim Robbins, but you probably also think of Tim Robbins, all of his seminars and all of his, sorry, Tim, I keep saying Tim, Tony Robbins. Maybe he's not famous in my mind. Tony Robbins, all of his coaching and all of his seminars and all of the stuff that he does, as much or more than the actual individual person. He's a persona. He's a famous person and has that brand. So it's something he could protect that you and I probably couldn't until we get to that, somewhere closer to that level.
yeah, that's the thing, right? Because I think that's also very hard to predict, like when that happens and how exactly from a legal perspective. Because at the end of the day, let's say you build a personal brand, you get a lot of following, you get their traction, and you're being known as a expert in that field. But what's the threshold like? If they search for your name online and it gets associated with that expertise, or
There's black and there's white and there's a lot of gray in the middle in this question. And so there's something that we don't need to dive into it in detail here, but there's something that the trademark office would say, okay, send us some indicia or some indicators of secondary meaning. What that means in normal language is send us the reasons why people have associated the name with the brand more than the name with the person. So send us the secondary meaning is it really refers to not just, there's a primary meaning. Jeff Holman means me as a person, but if Jeff Holman also means, fractional team legal services, show us surveys or market data or perhaps reviews or, confusion in the market. People are like, oh, there's a person named Jeff Holman. I didn't know that. I was looking for XYZ. Show us the data, the evidence as to why the market is associating the name with the branded services rather than with the individual. And so you've got to come up with that as the owner of the trademark. You've got to come up with those things, those secondary meaning indicators, and prove to the trademark examining attorneys that you actually, in fact, have more meaning to what you're doing. This is all one side of the trademark world. There's another side that might be worth mentioning because I think it's easier and I think it's a funner side to be in, even though it's a little frustrating sometimes. It won't be nearly as frustrating as the secondary meaning world, I promise you. When you pick a brand, there's some criteria that you can look at and you can estimate, you can, predict as to whether or not you'll meet the standard for being protected. Now, if you're in one of those classes where, it's outlawed to be trademarked, you don't want to be there. If you're a generic word like consulting, I want to protect the word consulting for my consulting services. You can't do that. It's a generic word and everybody uses it and needs to use it to describe what's happening. So generic is the bottom tier of these four tiered. Then you have what's called merely descriptive. Well, maybe it's not the generic word, but what you're calling it is just a descriptive word, like business advice for everyone. Okay, well, that's not really consulting, but that's all you're doing is describing the thing that you're doing, even though you're not using the same word that everybody else is using. You're just describing it. That's not going to be enough to get trademark protection, right? You've got to get into the top two layers here. One is the first of those two is a suggestive mark. So the mark sort of describes what you're doing, but not directly. It's not merely descriptive. It has some other elements to it. Somebody has to think and they have to say, oh, well, I didn't, okay, now that you explained it, I get it, but it didn't automatically tell me that what you were doing. And so as an example of that, my law firm name might be one example of that, right? I haven't had anybody tell me yes or no, whether it's which layer it's in, but my law firm started out doing a lot of intellectual property and we think of ourselves as being very strategic. So, several years ago, we called ourselves Intellectual Strategies. Now, nobody uses the phrase intellectual strategies for anything except us for our law firm. It's really close to being, strategy consulting or intellectual property. So it sounds a lot like those things, but the phrase itself, intellectual strategies, isn't really used much at all out there. So when we picked that, somebody might have said, well, I think I could guess what you're doing, but I'm not totally sure. That's probably a suggestive mark. And you're above the threshold to be able to get trademark protection. And then the top one is when you have made up words or names that have no association with the types of products you're selling. Apple computers. Apples have nothing to do with computers. And so, nobody thinks of computers when they think of Apple, except for the fact now that Apple is, is the brand that they are. Coca-Cola, that's probably I assume a made up name. I don't know if the word cola meant anything at the time that they established it. Made up names like Xerox, right? Kleenex, things like that. Those are just all made up, fanciful coin phrases, arbitrary associations. Those are the top layer. So when you start thinking about these 4 layers, when you're picking your brand name, it can become a lot easier to try to slot yourself into the right category that you want to be in from a marketing perspective, rather than saying, I'm just going to wait, and in 6 or 8 years from now, I'll prove to people that I've got all these secondary and, these indicia of secondary meaning, this evidence that I've become famous. That's a way to do it, but it's not nearly as regimented and structured as using these criteria for distinctiveness.
Love that. Now it's much more clearer. And I think I can give you as well an example from my business. For example, my business name is Digital Finest. Kind of say that it's in a digital space and so on, but doesn't say much. But when it comes, for example, to my framework, it's the client acquisition map. Kind of saying almost what it does, but not that clear. So that's a good example for the top layer, like Digital Finance top layer. And the second one that you mentioned in your case with intellectual strategies.
Words as opposed to generic, descriptive, suggestive, and then arbitrary and fanciful. So perhaps that might be in the suggestive layer of distinctiveness. So it kind of comes down to what the words are, what they mean normally, and how you're using it, and what types of services you're selling with it. And if there's a connection, or if the connection is like kind of one-to-one, or if the connection is a little bit more distant, and somebody has to say, well, I think I know what it is, but tell me exactly what you do. Then if that's the question you get, that you're probably in the suggestive world. I have attorney friends, we've been going to lunch since law school, and they come to me and they're like, intellectual strategies, like, I thought you did patents. Like, what are you even doing? What do you do these days? So even being in the field, they don't immediately understand what I'm doing. And that's the trade-off too. The further away you get from what you're actually doing, the descriptive generic words, the further away you get, the more work you have to do typically to educate the market as to what it is you're selling, right? So I often will suggest to people, and you didn't ask this, but I'm going to offer it because I think it's one of the things that I typically tell people is, I like to, for branding purposes, I like to pair up one of these trademarkable words or phrases with a really descriptive tagline, And so mine might be intellectual strategies, a law firm for startups, right? I can't trademark a law firm for startups, but I can trademark intellectual strategies. But people won't know what intellectual strategies means unless I tell them we're a law firm for startups. And so putting those two together, again, comes back to these layers. You have a couple different layers in your branding. Some of them are protectable and some of them are not protectable, but they're really helpful from a perspective of educating the market as to what you do.
Yeah, I love that. And to continue the example, so people get a better feeling of how this works. For example, if it will be a descriptive of my own, like Digital Finance, the client acquisition map, and then helping established coaches and consultants productize their knowledge. And that's, yeah. So hopefully those listening now have a better understanding of the intellectual property world, because it's important to understand that protecting your work and protecting your brand is, and especially today's world where we go global, we are at a stage that people are getting knowledge much more easier from the internet than ever before. So, and AI coming, and maybe we'll do a re-recording of a next episode or something about the AI world, because I think it will be harder and harder to protect anything like your voice, your
image and likeness. Yeah, it's gonna be crazy over the next several years, and it'll be chaotic. So for somebody like me, I'll be excited to see what happens.
Absolutely. So Jeff, please tell those listening where they can get in touch with you and work with you.
Certainly. So you can go to my website anytime. It's intellectualstrategies.com. And I offer new clients a free strategy call. If there's anybody who wants to jump on a call and kind of talk through the issues you're dealing with, happy to do that. So intellectualstrategies.com for a strategy call. And I'm also pretty accessible on LinkedIn. Just look for me. You'll see something in my tagline that says something about building fractional legal teams for startups and scaling businesses.
Awesome. And I'll put the links in the show notes as well. And to wrap up, please give those listening a quick challenge they can apply in less than 1 week to start protecting their brand. What will be the easy steps to go that path?
So I think going back to the trademark conversation I think that the challenge I would give to people is go back to your branding and see if you have the 2 layers that we talked about for branding. What is the unique part of your branding that you could probably protect with a trademark? And then what is the descriptive part of your branding that tells people what you actually do? And are those 2 things, are you using them together in a cohesive way so that people can start to create, because it's all about association, start to create the association between your unique words or phrases and your descriptive words and phrases. And once they make that connection, you're now well on your way down that, what's the framework for relationship sales, right? Know, like, and trust. They begin to know who you are and what you do because you've just told them who you are and what you do. So that's where I would start. I would invite people to start there.
Brilliant challenge. Thank you so much for sharing that. And thank you so much for joining me today.
Thank you for having me. It's been great.
You, yes, you're one of the few that stick to the end. And I want to thank you from the bottom of my heart for doing so. If you haven't subscribed already, please do so below. And if you got any value from this, please share it with a friend. They might got some value from it as well. Thank you so much, and until next week, pura vida!